Good morning, good afternoon, and good evening, and welcome all of you to the last in this year's Administrative Law and Governance Colloquium on executive power. We've been discussing executive power over the course of this year's series, the site of passionate debate, of course, in liberal democracies for many centuries now. In recent decades, authority is concentrated in the hands of presidents and prime ministers, with voters increasingly looking to these office holders to give effect to their policy preferences. Questions about the scope of authority and accountability of presidents, prime ministers, and other executive officers have therefore become even more pressing. What powers does and should the executive have? Against which standards should these office holders be judged? And who should do the judging? In this year's series, we've been examining the role of constitutional text and tradition, other governmental institutions, and civil society in granting and constraining executive authority, setting standards, and holding the executive to account. My guest today is Professor Ariane Vidal-Naquet of the Université Aix-Marseille, where she teaches public and constitutional law. She previously taught at the Université Droit et Santé Lille 2 and was an adjunct professor at the Université Paris 2 Panthéon-Assas. She's an active member of thesis review committees and has published numerous articles on constitutional law and the separation of powers, including detailed pieces on the role of the executive in France and on the judicial branch. The particular interest in having Professor Vidal-Naquet with us today is to discuss a chapter she did for an edited collection by Marcel Morabito and Guillaume Tussaud, entitled Comparative Executive Power in Europe, Perspectives on Accountability from Law, History, and Political Science. And Professor Vidal-Naquet was tasked with the difficult job, done very elegantly, if I may say, of providing a critical overview of forms of responsibility of the executive. She'll tell us more about this paper, and I'm very pleased, Ariane, that you're joining us. I'm going to share the PowerPoint presentation that you've presented, and otherwise we'll be quiet while you are introducing your work, and then, as ever, there's going to be plenty of time for question and answer afterwards. So, Ariane, c'est à vous.
Okay, thank you very much. Good morning, good afternoon, good evening, everybody. I'm very glad to join you to accept your invitation for this seminar. So, just you already introduced myself. I'm Ariane Vidal-Naquet. I'm professor at Aix-Marseille University, and my teaching and research interests are constitutional law, judicial review, fundamental rights and freedom, and comparative law. And just right now, I work on several search fields, and these 2 last months I study particularly what I called unconstitutional practices in France. And I wrote a little newspaper article which triggered a little controversial in France with another professor in Paris. And it's a bit uncommon in France to have to face such controversial. And I think it's very interesting. And that means that this, what I called unconstitutional practices of power, is a very sensitive subject. And I just plan to organize a big conference on this subject. And maybe, Paul, you will join us for this conference. So today you asked me to present my chapter to the Morabito and Tussaud volume on comparative executive power in Europe, perspectives on accountability from law, history, and political science. It was published in 2021, and this book provides an up-to-date interdisciplinary assessment of the accountability of executive power in different European states, about 15 states, and at the European Union level. So I would first like to introduce you to the objective of my chapter. So this chapter is called The Forms of Responsibility of the Executive. And it was supposed to be a transversal chapter, an overview, you said, Paul, which was relying on different national reports. And indeed, I read and analyzed the 15 different national reports and tried to gather reflections about the question of the forms of the executive responsibility. So to start, I would like to present my first observations upon reading the different national reports. To begin with, I noticed that the national reports use several terms to qualify this responsibility, such as, I quote, political accountability, legal responsibility, penal or criminal liability, civil liability, judicial liability, constitutional responsibility, electoral responsibility, or media responsibility. And few of the national reports care to define what those different forms of responsibility mean, as if it was very obvious. Secondly, few of them has precisely defined what responsibility should mean, so that when reading them, no generic concept emerges. And thirdly, the terminology itself fluctuates. When the French only uses one word, which is responsibility, English uses 3 words to refer to a reality that seems close. These 3 words, you know them: liability, responsibility, accountability, which opens a whole series of possible combinations and correspondences. For example, we may ask if the French conception of responsibility refers to responsibility only, to one or the other of the other notions, I mean liability and accountability, or even to none of them. So that was the first series of questions. Then I tried to suggest a notion of responsibility. Paul, this is the other. Thank you very much, Paul. And I tried to suggest, to define the notion of responsibility, and I tried to define it from what I call a legal point of view, and more precisely from a normative point of view. For me, responsibility may be understood as a legal, or more precisely as a normative system, which organizes the consequences of not complying with normative obligations. And this definitions calls for several precisions. At first, I think that responsibility, in my point of view, responsibility is a legal system. That means it is provided for by the law, which allows to distinguish between legal responsibility on the one hand and other forms of responsibility, for example, moral responsibility, religious responsibility, social responsibility, for example. Secondly, responsibility implies failure to respect pre-existing normative obligations. So I chose this expression of failure of normative obligations, which for me is more neutral than breach of fault. Thirdly, responsibility, by organizing the consequences of the ignorance of primary obligations, is linked to the administration of sanctions. And that notion of sanction should not be reduced only to its coercive dimension. In my mind, it has a broader constraining dimension, and then may be understood as the birth of a new legal obligation caused by the ignorance of the primary obligation. That means paying damages, for example, or the resignation of government. So in fact, I suggest to retain a strict sense of responsibility, which is a normative system organizing the consequences of ignoring normative obligations by a form of sanction. In fact, as several articles, national reports underlined, responsibility has two meanings. In a strict sense, it is associated with legal sanction, what is called in the English report, for example, it is called responsibility. In the Swiss and Dutch national reports, it is called responsibility sanction. And in the other sense, the broad sense, responsibility is dissociated from legal sanction and refers to a wider phenomenon of accountability. So I retained the first sense of responsibility in my chapter. So in this chapter, I also tried to precise executive responsibility, which includes for me the head of state, the government as a whole, and ministers. But in some national reports, they included advisors or even administrations working who may be concerned, which underlines a form of translations of responsibility, but I will go back on this point later. I also tried in my chapter to specify what forms of responsibility means. So the different national reports deal with several types: political, legal, penal, civil, judicial, constitutional, electoral, media of responsibility. All these terms seem rather intuitive, uncertain, and sometimes contradictory between the different national reports. I also tried in my chapter to take into account that a lot of national reports insist on national specificities, which are linked to political, cultural, legal, social, historical, or even philosophical characteristics. But despite all these specificities, I noticed that all the studied systems are parliamentary regimes today, except Switzerland, a system of which has at the same time presidential and parliamentary features. So now I will present, if Paul, you do agree, my main conclusions to you. Because reading the different national reports may give the impression that the forms of responsibility of the executive are multiplied. And for example, the English national report especially refers to a web of responsibilities, which seems, this expression seems to tighten the constraints that weigh on the executive in response to the role executive nowadays has within democracies. So this expression, web of responsibility, would let us think that the concentration of power in the executive hands is democracy compatible, to quote the Dutch national report, because this concentration of power is linked to the strengthening of responsibility. But I think that, and that's what I tried to suggest in my report, I think that such a movement is largely illusory from a double point of view. And the double point of view are a theoretical point of view and a practical point of view. So I tried to underline that from a theoretical point of view, the diversification of the forms of responsibility of the executive in reality corresponds to a weakening of the very concept of responsibility and to a shift of responsibility out of the legal field. On the other hand, from a practical point of view, I think that it is very difficult to hold the executive liable and especially politically accountable, which reveals the emergence of what I call a Platonic or even reversed parliamentarism. And I will explain all this in my presentation. So to begin with the first point of view, the theoretical approach point of view, we can argue that despite the appearances, the diversification of the forms of the executive responsibility does not imply a tightening of the constraints that it has to bear. On the contrary, I think it corresponds to the weakening of the very concept of responsibility, or even it's what I call, it corresponds to the dejudicialization of the concept, which contrasts with the concentration of the powers in the hands of the executive. So when I read the different national reports, it seems that several forms of responsibility of the executive emerge, which contrasts with the traditional irresponsibility of the latter, especially that of the head of state, which still applies in many states. So that diversification of the form of responsibility of the executive reveals the emergence of a new form of responsibility, or at least of responsibilities which seems more modern than others. For example, I could quote the criminal liability of the executive, which is essentially related to the ministers and in some countries to the head of states, or even in a more unprecedented way, some administrative agencies like in Poland, and which may be exercised in varied ways. I could also refer to political responsibility as a traditional form of responsibility. Political responsibility, which traditionally concerns the government in a parliamentary regime, but may also concern the head of state, like in Romania, for example, where the President of the Republic may be overthrown by parliament, okay, but even by some independent bodies, as in Poland, where the National Bank, for example, and the National Broadcasting Councils are accountable to parliament, which may dismiss them. Some articles also refer, and I forgot to put it on the PowerPoint, some articles also refer to some constitutional or political constitutional or criminal constitutional responsibility, which may be incurred for breaching constitutional obligations, or more precisely, provided for in the Constitution. But what is rather interesting is that several national reports note other innovating forms of responsibility, or more or less recently put forward. For example, partisan responsibility, mediatic responsibility, popular responsibility, or electoral responsibility. For example, it is said that there is a media responsibility before the media, and even more today, social networks. For example, the Netherlands report insists from that perspective on the difference between the official accountability instances, especially the parliament, and the non-official ones, in particular the media. Another example is what is called elective or electoral responsibility, which is mentioned, for example, in the Portuguese, Hungarian, English, Swiss, Polish national reports. This form of responsibility results in the non-re-election of the executive when it is elected, or in a majority not in favor of the executive. Some national reports also underline the existence of a popular responsibility, which is broader than the electoral one, which results in the reaction of public opinion and civil society. The latter could be measured especially through opinion polls or social movements and forms something like a continuous responsibility. The multiplicity of those forms of responsibility, traditional form and new forms of responsibility, raises very interesting issues as to how they are articulated, especially since there are many combinations. Are these forms of responsibilities exclusive or complementary or substitutional or even cumulative? For example, that's a very interesting question. It also raises the issue of seats or head of power. I mean, to whom is the executive accountable, being traditionally exercised before judges, for example, for criminal and civil liability, and before parliament, for example, for political accountability. It is today exercised before the media, the people, the civil society, which reveals a relocation of the seats of the accountability of the executive. But into my mind, this leads to the marginalizing of the political accountability of the executive and to the weakening of the executive's accountability. I think you can put the other slide. Okay, thank you very much, Paul. So what I call the weakening of the executive's accountability. I think that today's political responsibility is no more than one form of responsibility among others and tends to be diluted in the other forms of responsibility, which seem very more modern and which seem very more efficient. And I will come back to this point later. Moreover, I think that the multiplication of the forms of responsibility shows the shift of the issue out of the legal field. So here I have to precise that I include in the legal field criminal liability, civil liability, and even political responsibility. Indeed, in my sense, and despite its name, the political accountability of the government, parliament, belongs to legal responsibility. This question is not so clear in doctrine, and several national reports took a lot of precautions on this question. In my mind, there are legal provisions that require the obligation for the government to be supported, positively or negatively, by a majority in the lower chamber or even in the upper chamber, without which this majority, it may be sanctioned collectively and or individually. That's why, for me, we can talk about a legal responsibility talking about this political responsibility. On the contrary, I think that other forms of responsibility than the partisan, like the partisan, popular, media, or even elective forms of responsibility are not provided for in the law. For example, a political party withdrawing its support of the government, a negative answer to a referendum initiated by the executive. Another example, the non-re-election of the incumbent president, do not legally sanction breaches of pre-existing obligation and therefore do not belong to the legal concept of responsibility. And that's why I suggest that those new forms of responsibility reveal a shift of the mechanism of responsibility out of the legal field toward the political, the social, the moral field, which consequently entails a de-juridification of the responsibility of the executive. For me, all these forms of responsibilities are, I quote, Canada Dry responsibility. That means it looks like a beer, but it's not a beer. That conceptual shift seems in some ways to be the consequence of the difficulty there is to involve the responsibility of the executive in practice. And from that point of view, almost all national reports insist on the dysfunction which especially impact the political responsibility of the executive. This kind of political responsibility is seldom or even never involved, so that it becomes almost platonic. And that's why national reports tend to imagine and support other forms of responsibility. So I suggest we can move to the other part of my chapter, thank you, Paul, which is a practical approach. So from a practical point of view, I mean the practice of responsibility, a lot of national reports underline the malfunctions which affect political accountability, whether in its use or meaning. The instrument of political accountability today seems less and less used in Parliament, which may be interpreted as a sign of de-parliamentarism of parliamentary regimes. And reading all the national reports gave me the impression of a cycle of political responsibility, which appeared in practice, but which is nowadays disappearing in practice, and which then could almost seem as an historical contingency. Indeed, many national reports underline the clear weakening, if not the complete disappearance, of political responsibility, at least in its most radical form, which is sanction, that is, for example, the overthrow of the government. That's the case in Nordic countries, in Hungary, in Poland, in the United Kingdom, in France, in Germany, and even in a mixed regime like Switzerland. Well, you can take the other slide, please, Paul, thank you. So we can identify 4 reasons for this. First, overthrowing the government may seem to be a disproportionate measure, especially when there are alternative mechanisms to hold ministers to account individually. Secondly, it may seem inappropriate in some cases, especially when it is difficult to attribute responsibility, as, for example, in minority governments. Third, it may seem useless or even nonsense in a partisan logic of support of the government majority. Finally, it may seem as a risky weapon insofar as overthrowing the government may trigger dissolution as a retortion measure. So we can understand that this quasi-disparition of political accountability implies the revival of other forms of responsibility that were thought to have died, or the apparition of new forms of responsibility. For example, you can take the other slide. For example, criminal responsibility may appear nowadays in some countries as a substitute for political responsibility. It's the case in France, for example. For the COVID, the government regulation of the COVID, it was impossible to overthrow the government. So what happened is a criminal responsibility, and nowadays the government is prosecuted in front of la Cour de Justice de la République, the Republic Justice Court, which is a penal court. Another example is that the quasi-disappearance of political accountability also leads to the apparition of new forms of responsibility, the ones I mentioned earlier: media, partisan, popular, elective. And the cycle seems to be vicious. I mean, the weakening of political accountability because of partisan concern results in a new mechanisms of responsibility, which in return marginalize political accountability, but that creates a vicious circle. And the disappearance of political responsibility may be interpreted as a sign of deparliamentarization of political regimes. So I think there is two senses of this term, deparliamentarization. In the first sense, it refers to the loss of the characteristic of a parliamentary regime. And in a second sense, the parliamentarization refers not to an issue of classification of legal regimes and identification of the parliamentary regime, but to a question of sets of power. And in that sense, the second meaning, the parliamentarization means that it is no longer the parliament which holds the power to account. As is revealed in the appearance of new forms of responsibility, accountability does not occur anymore in parliament, but outside the parliament, before the people, before the media, especially. So the parliament is out, and that's why I used this term of deparliamentarization. Another big question, a second one, is sorry, I forgot this one. Okay, can you put? I'm sorry. So that's what I just said about the deparliamentarization. And yes, I can add that the disappearance of political responsibility tends to reconsider the combination between two traditional tools of the parliamentary regime, which is the overthrow of the government and the dissolution. Because the implementation of the so-called political responsibility of the executive, I mean overthrow of parliament by the government, is extended or even supplanted by the triggering of its electoral accountability, approval or disapproval by the people. And the dissolution is also a question of electoral accountability, I mean the accountability of the parliament in front of the people. And finally, these two mechanisms, overthrow of the government and dissolution, are only question of electoral accountability. And that means that these mechanisms stand in front of the people and exclude the parliament, which is out, as I said before. A second big question, thank you, is that maybe this disappearance of political accountability is linked with what I called distortion of political accountability and may lead towards a reversed parliamentarism. So many national reports defend the idea that there is some correspondence between power and responsibility. Whoever had the power must be held responsible. And this logic may also be reversed. Whoever is accountable must have the power. But it's not really the same meaning. Paradoxically, historical evolution shows that reversal of logic in quite a few countries. I mean, a powerful or even all-powerful head of state, a government which becomes accountable to parliament, which progressively leads to a transfer of the power of the first to the second and the marginalization of the former. So I think that two situations may reveal a form of what I call distortion of political accountability. The first situation is that of the delinking of power and accountability. This could be illustrated with two examples. Thank you. Two examples, the Romanian and French examples. In these two cases, the responsibility of the government before parliament coexists with the presidentializing of power. In the French case, for example, the President of the Republic, who has strong democratic legitimacy, determines and almost conducts the policy of the nation. He cannot be dismissed by parliament and is therefore not politically accountable to it. In the Romanian case, it's different because the president is also very strong. The president has also a strong democratic legitimacy, but he is accountable to parliament, to the people, and to the judiciary. The second case of this disconnection of power and responsibility is about the relations between the government and its administrative circle, and therefore between the political and the administrative field. Such a form of deresponsibilizing may be analyzed as a strategy implemented by the executive to escape accountability by delegating decision-making and diluting decision-making routes. The second shift is not a distortion of political accountability, but an inversion. Thank you. I mean, it is not the government which is accountable to parliament, most often to the lower house, but parliament, which is accountable to the government. That reversal of logic, that reversed parliamentarism, is quite very highlighted by the Hungarian, English, and French examples. It essentially results from the fact that parliamentarians are politically and legally dependent on the government. I mean, politically, for in most of the studied countries, the prime minister, head of the government, is also elected to the lower house, but is above all the leader of the majority in parliament, that is, the leader of the political party which gives the government its majority. Legally, since parliamentarians are exposed to the right of dissolution, which precisely belongs to the prime minister in most of the studied countries. As underlined in the Hungarian article, National Report, that reversal of logic raises many questions, especially as to the protection of constitutional parliamentarism. That expression, I borrowed it to the Hungarian National Report. That expression of constitutional parliamentarism not only refers to the parliamentarian regime as a legal technique of distributing power, but also, and more fundamentally, to a certain conception of parliament as a set of power, a conception that is widely mistreated by the establishment of reversed parliamentarism and the quasi-disappearance of the accountability of the government. Those practical dysfunctions, and that's my conclusion, those practical dysfunctions of political responsibility explain, in their turn, theoretical shifts, the valuation of other, of extra-legal forms of responsibility to compensate for the marginalization of political accountability in particular. This is what I call, what we can say, an illustration of the relations between the law, the practice of the law, and the discourse on the law. It can also be seen as a call for imagination, an invitation to modify the legal norms about the responsibility of the executive in order to better take into account the reality of power, which today is concentrated in its hands. Thank you.
Well, thank you very much, Professor Vidal-Naquet, for that wonderful overview of a chapter which is intriguing, interesting, and provocative. And if anyone has any questions or comments, you can, of course, put them in the Q&A box. I was one of the authors of one of the national reports in this book. I did the report on England. And I had, I would say, a fairly sanguine, optimistic view of accountability in the English system. I think many of the national reports were optimistic about what was happening in their own systems. But
you found them optimistic?
Well, sorry. Well, I'm me, yes. Some of the others less so. But I was wondering if you think that it is possible that when you're in a particular system and you think it is functioning well, you are inclined to take a rose-tinted view of accountability, and certainly I was guilty of that. If we're in a system where we think the system is functioning relatively well, we perhaps don't ask ourselves hard questions about the morphology of accountability that you've discussed. I thought that was the great value of your contribution.
Yes, I do, if I may answer. And let me just apologize for my English, which is not very, very fluent, but I hope that's why I made a PowerPoint so that everybody can follow the presentation. So
you speak English better than many Anglophones whom I know. No worries.
Okay, so I think that when I read the papers, the national reports, if indeed you can say some of them are very optimistic, but I think that they tend to retain a very broad sense of responsibility. And that's because it's more optimistic to say everything is okay, but we just have a very, very, very broad notion of responsibility. I mean, if the prime minister is non-reelected, that means he's responsible. Yes, but what is the sense of responsible? No, it's not responsible. It's just a democratic way to rule, but that's all. It's not a kind of form for me. It's not a form of responsibility. And that's why I think that I'm not very proud of my own definition of responsibility. I think it could be amélioré, it could be better. And I think there is a big job which can be made on this question of how you could define responsibility. And of course, the conclusions you may have depends on what you call responsibility. In France, nowadays, we could argue that everything is okay because President Macron is very responsible in front of the people. In fact, for example, he's not responsible, but because in France, like in the USA, the presidents can only present 2 mandates. So he's no more responsible. If he's not elected tomorrow, it's not a kind of responsibility. So it's very interesting, and I think that there is a big research which could be made on this question, how to define responsibility, and especially political, but also other forms of responsibility.
I can see a couple of, 3 now questions in the Q&A, but there was one thing I did want to ask you just to say a little bit more about. I quite liked your definition of responsibility and linking it to the notion of a legal sanction to try and tighten up. We often talk about accountability in very loose terms, and so some analytical rigor is helpful in my view. You mentioned the shift from political responsibility to criminal responsibility, and you mentioned the COVID in France and prosecutions before the Cour de la République. I was wondering if you could say a little bit more about that. I mean, I would look at criminal responsibility as also containing a sanction, a legal sanction. Yes. But the shift then from political responsibility to criminal responsibility might be seen to be a good thing because it puts it on a legal basis.
Yes, so I do agree that for me, and due to my definition, to my concept of responsibility and legal responsibility, I do agree that criminal liability is a legal responsibility. It is provided for by law. But I think that because it is very difficult, and I would rather say impossible, to overthrow government in France, because political responsibility does not exist at all. It's not possible. In France, during our Fifth Republic, since 1958, government has been overthrown just one time. It was in 1962. And since 1962, no government has been overthrown. If I go back to the COVID crisis, government was very attacked after the crisis because of its gestion of the crisis, but parliament cannot overthrow government because it's the same majority. So, because it is impossible to overthrow government, a lot of citizens have started prosecution of ministers before la Cour de justice de la République, which is a penal responsibility. And it's some kind like a substitute. This criminal responsibility is a kind of substitute of political responsibility, but it's not the same at all. For example, the prosecution before la Cour de justice de la République is for very important infractions, I don't know, infractions such as mise en danger délibérée de la vie d'autrui.
Yeah, an offense of endangering the life of another, which would be a very broad.
It's no more political responsibility. It's no more you have not taken the right decisions at this time. It's you wanted to kill people. It's not the same at all.
Okay, so going to the questions. So Martha McDougall asks whether if the problem of responsibility you describe, that it's taken out of the hands of Parliament, is that unique to France? Or another way to put it is, I suppose, what other examples would you give, as well as France, where we see this phenomenon?
So could you repeat your question? Because is it a question in the chat?
It's in the Q&A box. It's the second question, and it's posed by Martha McDougall.
Oh, okay.
And you see there, is the problem of responsibility described unique to France?
Okay. No, as I tried to say that my main conclusions of my chapter is the results of the 15 national reports. And what I tried to highlight is the same for France, but for Romania, for Polonia, for Great Britain, for a lot of the great majority of the countries which were studied.
Now, the first question on the list there is from my colleague, John Mark Keyes. And at this moment in history, it's impossible to talk about executive power and accountability without talking about the coming election in the United States. And he asks whether you would agree that President Trump is an extreme example of popular accountability displacing legal accountability, which will come to a head if he's elected in November. Are there any comparable developments in Europe with populist leaders? Is the question. But if you have any thoughts on President Trump, I think we'd all be happy to hear them.
Yes, I can answer. Yes.
Yes.
Yes. Yes. Yes, I think that when I read the Hungarian report, when I read the Polonian report, it tends to be the same. So you can be optimistic and say, oh, it's wonderful because all these presidents, all these leaders, very popular leaders, are very responsible before the people. But it's not, for me, it's not a form of responsibility. And moreover, in this kind of countries, what we call illiberal regimes. I think that there is one degree more, which is the leader is responsible before the real people. We have to distinguish between the ordinary people, it was before, and all this what we call illiberal democratic countries just want to represent the real people, and the real people is not the elitist people, and is one kind of people, you know.
Very good. Next question. Do the courts play a role in holding governments accountable? Not necessarily criminal, but in administrative proceedings where you can blame the state for wrongdoing and rule in favor of the people.
So it's true. Thank you for this question, because it's true that now the question is here. I realized that few national reports, even more, very, very few national reports talked about administrative responsibility. And even in my national report, I didn't take into account this administrative responsibility, because it is linked to the executive, of course, but it is like a form of state responsibility, which is not the one of the executive. And that is also linked to the definition of what we call executive responsibility. Is executive responsibility only the elected people, or for example, the president, the government, or can we include in the executive power all the administrative? But now I read this question, I remember that in some national reports, I think maybe I don't remember, but I think it's like Netherlands, I think, I'm not so sure. The national reports tried to explain that sometimes the administrative responsibility was used as a substitute of political responsibility. So that may answer this question.
Thank you very much. And last question, a slightly long one from my colleague Steve Chaplin, but nonetheless articulating some thoughts that I also would be interested in having your reflections on. And that's about the strengthening of political parties and the resulting tribal politics. In a Canadian system or the English, the Prime Minister is leader of a political party, head of the executive. He controls the political party. This means that he controls his parliamentary majority. This means control of the lower house of parliament, and that then limits accountability to Parliament. It limits the role of the legislature and encourages political or parliamentary sycophancy. It also makes it
sycophancy.
Sycophancy, members of Parliament being obsequious.
Okay,
servile. Yes, very good. And so, yeah, so the question then that he ends up posing is, do we need more control of political parties? What do you think?
Do we need more control of political parties? That remark is linked with what was called the political responsibility. And in fact, for example, in the English national report, and you said UK, yes, in the English national report, it is said that their responsibility is just in front of the political party, and we do not need more parliament anymore, just between the government and the political party. So do we need more control of political parties? I'm not so sure, but I've got a French point of view. And in France today, our political parties are in a very, very, very strange situation, because it's very difficult for the ancient parties, political parties, I mean, la droite, the right, and the left. And this kind of traditional parties have almost disappeared of the political landscape, which is now occupied by the extreme wing, left and right. And in my point of view, but which is a little biased, I don't know how to say that, by this reality, I think that it would be very dangerous to give more control to political party.
Thank you very much. One last question for you before you go. You did at the very end talk about the possibility of reform and the need for imagination. If you were able to implement some reforms, what would the most important ones look like?
I don't know. In reality, in fact, and if I take the example, the case I know well, which is the French case, it's very strange because in France, our parliament is very weak. But he is, in fact, he is politically weak, but not legally weak. It's very strange. And that's what I call the inverted parliamentarism. I think that if parliamentarians were more independent from the government in France, not the government, the head of state, the President de la République, because in France, the leader of the political majority at the lower chamber is the president. It's not the government. The government is just, we usually call him in France un fusible. You know, Paul, what is un fusible? And when you have electricity, you know, like a board of electricity with a lot of little buttons, and when there is un court-circuit.
Yes, yeah, well, I suppose it protects you from.
Yes.
Yes.
That's it. So in France, we say the Premier Minister, the Prime Minister is a fusible, and there is only the head of state and its majority at the lower chamber. And due to this link, very, very strong between the head of state and the parliamentarians, they do not dare do anything, and they are very how do you call this? Sycophantic? No,
sycophantic, yes, sycophantic.
Okay, and but it's only a political point of view, because legally, legally, the parliaments have the power, the competence to overthrow the government. But because he's so weak in front of the president, and because he knows that he's dependent from the president, the parliament do not dare do anything. So I think that if I could suggest something, it would be on a political level more than on a judiciary or legal level.
Well, thank you very much for that response, and indeed for a fantastic presentation of a very thought-provoking and an interesting chapter with, as I suggest, a little bit more analytical rigor than sometimes we get when we think about accountability and responsibility. So thank you very much, Professor Vidal-Naquet.
For your invitation.
It was a real pleasure, and thanks to all of you who have participated throughout this year's colloquium series. I'll be back in 2025 with another series on the legitimacy of judicial review. Until then, do stay in touch and keep safe. And thanks again, Professor Vidal-Naquet.
Thank you very much, everybody. See you.
All the best. Bye-bye.
Thank you. Bye-bye.